In a big development, Bilkis Bano has approached the Supreme Court of India in a writ petition challenging the premature release of the 11 convicts sentenced to life for gang rape and murder during the 2002 Gujarat Riots. Bano has also sought a review petition against the Supreme Court's judgment allowing the Gujarat Government to make a decision on the remission of the released convicts. Today, Advocate Shobha Gupta, appearing on behalf of Bano, mentioned the petitions before Chief Justice of India D.Y. Chandrachud in the morning. She pertinently expressed a doubt if the bench led by Justice Ajay Rastogi, who authored the previous judgment allowing the state of Gujarat to decide the remission plea, would be able to hear the matter as he is now in a constitution bench hearing. To this, Chief Justice of India D.Y. Chandrachud stated, and I quote, "The review has to be heard first, let it come before Justice Rastogi." When Advocate Gupta submitted that the matter had to be heard in an open court, the CJI underscored that only the court can decide that. Accordingly, CJI Chandrachud said that he will decide on the listing after looking into the matter in the evening today. To provide a bit of context for all of you, back in May this year, a bench of the Supreme Court of India led by Justice Rastogi had ruled that the Gujarat government had the jurisdiction to consider the remission request as the offence took place in Gujarat. The Gujarat High Court had earlier held that the remission had to be considered by the state of Maharashtra as the trial was held in Mumbai upon transfer from Gujarat. Later on August 15th, all the 11 convicts were released. Visuals of the released convicts getting a heroic welcome became viral on social media, leading to widespread outcry among several sections of the society. In this background, a bench of PILs were filed in the Supreme Court questioning the relief granted to the convicts. CPIM leader Subhasini Ali, journalist Revati Lal, TMC MP Moha Moitro, former IPS officer Miran Chadha Bodwankar, and few other former civil servants, including the National Federation of India Women, etc., were some of the petitioners in the PIL. Responding to the petitions, the Gujarat government has told the Supreme Court in an affidavit that the decision of remission was taken after the approval of the central government, considering the good behavior of the released convicts and the completion of the 14-year sentence served by them. The state's affidavit also revealed that the CBI and the presiding judge of the trial court, that is the special CBI court at Mumbai, had objected to the release of the convicts on the ground that the offence was grave and heinous. The annexures in the state's affidavit also showed that one of the convicts was booked for sexual harassment of a woman while he was out on parole in 2020. Now the survivor of the crime herself has approached the apex court of the country, questioning the decision to release the convicts, as we wait and see how the Supreme Court addresses her grievances. Thank you. I'm Maratra Kabhamik for Live Law. Keep watching Live Law for more such updates.